the workload because of the other type of work that I had been doing before that.
Just to explain, when you do appeals, you usually do appeals with another judge.
Yes.
Yes, and how did you get on with your co-judge, if I may put it that way?
They were very helpful. They were very supportive. We discussed the matters, and I did not have any problems with any one of them.
Yes.
In the matters that I said, and I had to be the scribe, they were very helpful and supportive as well.
Yes. Did you find the work challenging, and do you believe you can cope with that?
It actually goes back to being an attorney.
Yes.
My principal, when I was doing articles, said to me that he had read an article about somebody who had gone to the US and wrote an article in the Derebus and had said that the practice of law is a lifestyle. And if you intend on doing that and doing it correct, then you must adopt that attitude. And I have since lived with that attitude.
You have done criminal work before. Well, let me put it, you have acted as a judge in the criminal court.
Yes, during the last session.
Yes. But your practice as an attorney, did that involve any criminal work as such?
I did a bit of criminal work when I first started.
Yes.
Did a few bail applications. I had not done a criminal trial. I had done criminal appeals. And I, before acting in court, sat as an assessor in some of the criminal cases.
Yes. How did you find that type of work?
It's challenging. It's interesting. You deal with people and people's emotions in criminal matters. You get to interact with people, and it's therefore necessary and important that you get the people to develop some trust and comfort in the system, in the manner in which cases are being dealt with.
You have, been acting in the High Court, as you said, for about 5 sessions.
Yes.
In your experience, do you think people react differently to you as a female judge and to the male colleagues? Do you have any comment on that?
I believe so. In the rape case that I did recently, or involving persons who were raped as minors, they looked very relaxed and open and free to give evidence in the court, in the manner, I guess, of the fact that I'm a female, and in the manner in which I conduct the court in general.
And as a female judge, are there any specific challenges that you can think of that you think that's unique to a female judge?
There sometimes seem to be some sort of, I would say, undermining from senior counsel appearing before you as a female judge. As an attorney, some of them have an attitude that you don't know anything, you don't know your work, so you have to prove yourself to them that you know and you're capable of carrying out the duties.
I'm sure somebody else will ask the question if I don't. Why is it that you want to become a judge?
Because as a young child, I used to go to the maintenance court with my grandmother, and what I observed is that justice was not being dispensed properly in those courts. And as I grew up, I told myself that I'm going to become an attorney and assist people who were not getting the justice that they deserved. I ended up, obviously, as an attorney, and I continued to carry out those wishes that I had all along, assisting members of the public, assisting clients, in various areas of the law, and I now believe that doing it at a much higher level would be for the benefit of the entire society or community.
Thank you, JP. Premier?
Thank you very much, Chief Justice. The Judge President asks you about what is reflecting on your CV, which you've just explained, that finding by law society.
Yes.
How do you want us to treat this matter? Specifically, I want your response to reflect on I want your reflection legally, that legally, how do you see the case proceeding? Because we're told there's a pending decision on the matter legally.
Yes.
But then also too, how do you see it with regard to your own conscience? I know that such reflections that call for somebody's conscience or one's conscience are now very rare, those cases. We almost live in a world where consciences count for very little in what we do. But I'm wanting to reinforce yours, at least during this session, so that you take this opportunity and take us into confidence, but using your own conscience.
Yes.
You have applied for a very, very, very important position. Yes. Very, very, very important. That one that has very, very far-reaching implications.
Yes.
And to go there with this, there must be something in your conscience that say that is a minor thing.
Yes.
The application is bigger than this.
Yes.
Now, I want that because ordinarily you would have said, rather wait until this thing is cleared or not apply at all.
Yes.
But you seem to have, wanting to proceed. What is it that drives you nevertheless? So I want your response at two levels. Let me give you I have three other questions that will come.
Well, in the hands of the Law Society, they have finalized the matter, having issued a fine for me to pay. And that is what my appeal is about, because I believe that I took a decision, a legal decision, in terms of my legal duties as a practitioner. Obviously, the fact that I've appealed suggests that I disagree with the decision of the chairpersons, whose views seem to have been that I took a wrong decision, and in law, that I should not be penalized for having taken an incorrect professional decision in the manner in which they have. Hence, I've taken the matter on appeal, so that the courts could actually then decide and rule on the matter. But in respect of the issue of the conscience that you were talking about, the extent and the nature of the matter is such that the Law Society believed that I could proceed and practice as an attorney. It was not an issue that they would suspend me or strike me about. So I believe that they then have the confidence in me to continue as a practitioner to carry people's cases. So they believe that I can and I have that ability to deal with the case. Hence, they've indicated that this should then not be a bar to me having to deal with the matter. The Law Society has even further to that, following my the decision in my matter, appointed me as one of the examiners in the attorneys' practice and procedure exams, and it's a very important function for the Law Society. The South African Law Society has also appointed me in such similar position that's responsible for setting exams that relate or include, amongst others, attorneys' ethics. And if they did not believe in me and my ability to then carry out the duties or the members of the public or represent them in cases, then they would not have appointed me in such positions. They took those decisions being aware of the fact that I had that disciplinary decision. So, I believe that I'm capable of carrying out the necessary duties or functions of a judge with, hence I'm of the view that even if the appeal does not succeed, all that is required of me is to pay that fine. And that will bring the matter to finality. But I have a very strong belief that, I guess, because it's my matter and because I'm raising the issues, that I would succeed.
If I may, Premier, it doesn't go to your integrity or your honesty. It's about the understanding of the law, right or wrong.
Yes, that's this.
That's what basically I was looking for. I understand if the Law Society has confidence in you and they appoint you to do this and that, but I'm wanting the smaller voice in you. Is it saying, what an escape, or is it saying it should be the case? I'm free of any burden in my conscience that I did any wrong.
Yes, that's correct. As Chief Justice says, I believe that I'm a person of integrity, and I believe that the Law Society also believes that.
All right. Past that, the environment in which you are working currently, with regard to dominance by males, which you highlighted, is the environment encouraging for you? Is it discouraging?
It's challenging, but I am the type of person that does not shy away from challenge, and hence I have stayed. It is a difficult environment for females. Female organizations or in the legal fraternity have tried to tackle that problem, but they have been unsuccessful. Other institutions have tried to tackle the problem, but nothing seems to be happening. I think we have, through the PLA, tried to engage your predecessor, and I think there's current engagements with you. And I'm saying I think because I have since withdrawn from the subcommittee that was responsible for developing or drafting documents to be submitted to your office, and due to my studies had to withdraw from that committee. But at that time we had difficulties engaging with the relevant people in government to try and get some sort of support, some sort of assistance. So it's very difficult. In the private sector, it's even worse.
So you can refer us to specific cases where you would have felt challenged as a woman more than it would have happened to any other lawyer. There are instances of that nature. If you could give us one example.
Well, the issue that never escapes my mind is that now in this instance I was sitting as an arbitrator in a case, not appearing as an attorney. I went into the boardroom and I sat there, and attorneys walked in and overlooked me and did not even greet me, and I was sitting in a place where anyone could see that I'm a chairperson or I'm the arbitrator sitting there. After a while, they come to me and they ask me, "Are you the stenographer? Are we waiting for the arbitrator?" I felt very humiliated. In the past, people had said, "Well, maybe you need to change the way that you dress. Maybe that would assist." And I tried to change the way that I dress, and it didn't work. I still had the same problem that it continued to happen. People would just do that and not see that you are there. I think it's because they have in their mind a certain person who is an arbitrator, and that person is ordinarily some old or older-looking type of, firstly, white male, or secondly, a black male. I always even talk to my colleagues and I say to them, what you fail to appreciate is what a black woman goes through. You get to be looked down by, first, not being white. You get to be looked down by not being a male. And then you sometimes get to be looked down by even your own black brothers. I've had a case that people came in Pietermaritzburg and they looked at me. It's unfortunate that my face looks like I'm a very young person, but it shouldn't be a justification that black practitioners were appearing there, and they were very disrespectful. Some of them I've had to thereafter go and speak to their principals and say to them, are you aware that this person from your firm is behaving like this? They had to be called to order or being threatened by their other colleagues to say, you're being discourteous and you're going to be reported to the Law Society if you don't change your attitude. But it happens, it's challenges that people get to face, and we try to deal with them. Obviously, in time, when people get to know you and they get to be used to you, they start treating you differently. But when you each time go to a different place where people don't know you, you get to face the same treatment.
So these attorneys, were they males?
Yes.
All right. What needs to be done?
Wow. It's a difficult one because we are 20 years into our democracy. The Constitution professes something, and then people are acting in a different way. And these are educated people, so I don't know if I could say they need to be educated more, if that would change their mindset. But it's something that really needs to be looked at, and something needs to be done about it, because it destroys the confidence of black female practitioners.
Well, I'm sure that you are quite circled here, because I'm sure we recognized you as a candidate without any problem, and that nobody has done anything that makes you think you need to change your dress code or something like that.
Yes,
You're fine. The last question is, what are the challenges in society? Maybe using certain values that you identify with, that are on the decline or affected in any particular way, but that require the judiciary to contribute in a particular way in reviving such values as you may identify.
Well, the issue of equality, the issue of dignity, when you go to I think in the rural areas of KwaZulu-Natal, you'd actually find that there's still that, I'm not sure if it's a culture or what, of how the males act towards the females. And it's, I'm not too sure if what the role that the judiciary actually plays would assist. I know the Constitutional Court every now and then pronounces on those types of issues. I know that the High Court pronounces, but then whether these people get to actually have that information from those decisions availed to them is something else, because some of the people would obviously not have access to TVs, some of the people would not have access to radios, and decisions are made, proper decisions are made by the judiciary relating to issues relating to people's rights, but whether those get to be cascaded down to those people is something else.
Just a follow-up. With regard to social ills, where do we, as KwaZulu-Natal, seem to have the biggest challenge, which, of course, does require the contribution of the judiciary?
I think what you have is that in respect of our setup in the in our courts in KZN, persons using the courts would not have the confidence that when they approach the court, they would get the justice that they deserve. Probably because, whether we like it or not, there's the issue of socialization, and then when they look and they try to identify, they don't find the people that they can actually identify with in order for the issues to then be dealt with properly.
Commissioner Fourie, are you done, Premier?
Thank you very much.
Thank you. Thank you. Commissioner Fourie?
Thank you, Chief Justice. Good afternoon, Ms. Masipa.
Afternoon.
I unfortunately have to come back to the Law Society issue.
Yes.
If I understood your answer to the Judge President correctly, you said your client abandoned you.
Yes.
And you then, without instructions, told the court that your client is withdrawing his application and is tendering the costs.
No, that's not correct.
Okay. What is then correct?
The client abandoned me in court, and I had counsel appearing in the matter. I then said to counsel, I was actually told that the judge is now calling you back in court for you to come and obviously finalize the matter. The judge is at the end of the roll. The judge the client had asked that we ask for a postponement of the matter. We had made 2 attempts to ask for a postponement. The judge had indicated he is not going to adjourn the matter. I looked at 2 evils that were there. One was I would allow the judge to dismiss his matter, and the one was for me to withdraw the matter. And I felt if the matter was withdrawn, then it would have to go on appeal, whereas if I've withdrawn the matter, I could still have the matter reinstated and we can then deal with it. What I communicated, or what was communicated through counsel to the judge, was that we are withdrawing the matter and we are tendering the cost. It was never said to the judge that those were the instructions of the applicant.
But can you withdraw a matter and tender costs without having your client's instructions to that effect?
This matter was a bit peculiar in the sense that the client was not financing the matter, and I had previously discussed the issue of of costs in when matters are to be withdrawn with the insurance company that was financing the matter, and it was. They had in the past indicated to me that I could take the decision in order to do that. So it was an issue between me and his insurance company in respect of the costs.
The only point, and I don't want to belabor the point, but I personally regard it as fairly serious.
Yes.
You say in your own words you were found guilty for allegedly misrepresenting to court that the complainant had agreed to withdraw his application and
Yes.
tender costs.
Yes.
What we know from your own version is you didn't have instructions
Yes.
from your client,
Yes.
but you told the court that the application is withdrawn and that costs is tendered.
Yes.
But can you, and what further bothers me, Ms. Masipa, is that you now, in an answer to a question by the Premier, said that you think you did the right thing.
Well,
The only thing you could have done under those circumstances was to withdraw as the attorney of record.
but the rules provide that in order for me to withdraw as an attorney, I have to advise the client so that his interest is there. He's able to come and represent the client, and he can come and if he wants to represent himself, advise that he's representing himself, but he can take the decision thereafter on how he wants to proceed with the matter.
So, on your own version, with all due respect, Ms. Masipa, it was a misrepresentation to the court.
I did not. What the Law Society was saying is this: the client lodged a complaint, and in his complaint, he says she told the judge that I gave her instructions. And what I then said to the Law Society is that was never communicated to the judge. I never said to the judge that the applicant's instructions are these.
Okay. Let's leave it at that. I just want to go further. In your answer to the questionnaire, you say, misrepresenting to court that the complainant had agreed to withdraw his application and tender costs. Then you say, failure to carry out a court directive.
Yes.
And failure to supervise a candidate attorney.
Yes.
On the face of it, the way it's presented here, it looks to me like 3 charges.
Yes.
Were you
Yes.
found guilty on all 3 charges?
Yes.
What is the issue regarding the failure to carry out a court directive?
It's related to the same issue. What had happened was that the reason why we had to seek the postponement was because an affidavit was filed out of the time frame which was set by the court. And the reasons behind that were that the legal insurance company had withdrawn their instructions from me, and they had before we could comply with the court order, and therefore since they were the ones that had instructed me, I did not have instructions or a mandate anymore to act in the matter. And this was, the court order required that the affidavit be filed on the 2nd of November. Instructions were withdrawn from me about 3 weeks before that. I could not comply with the court order since I was no longer having the mandate from the insurance company. They then returned the files to me about a week before the matter was in court, because none of the other attorneys were prepared to take the matter. It was already out of time in terms of complying with the court order. A condonation application was prepared as required. However, when an application was made or a submission was made to hand in the documents to the judge indicated that he was not prepared to take the affidavit and the condonation application. He was not even prepared to listen to any submissions in that regard, and as a result, he indicated he was going to dismiss the matter. So it's
You say you didn't have a mandate from the client anymore. Did you then withdraw as attorney of record?
At the time, you mean at the time when the legal insurance company did take the instructions away? Yes, I did withdraw as attorney.
But how can you then be found guilty to have failed to carry out a court directive?
Well, I'm going to guess it was because the instructions were brought back to me. I did explain to them.
And the last one, failure to supervise a candidate attorney?
It's again in respect of the same issue. What happened was that the candidate attorney was to have obtained a copy of the court order in respect of that adjournment, or of that filing of the affidavit. We constantly made attempts to obtain a copy of the court order. However, the court order was not available from the Labour Court up until we were not on record in terms of that window period that I'm referring to.
Okay, and you say that your appeal against those findings are still pending?
Yes, it is.
Okay. Any idea when it will be heard?
The Attorneys Act requires for the Law Society to provide the record of the proceedings. The Law Society ought to have filed the record, and they have not done so. We have written to the Law Society requesting for them to attend to the filing of that record. They have not done so. At some point, they were even threatened, I would say, with a mandamus. They undertook that they were going to provide the record, but they have to date not provided us with the record.
So there's no date as yet?
No, there's no date.
Last question. You under reserve judgments, you left...
That will be the last. There are too many now.
Yes. It's just two issues, Chief Justice. Under reserve judgment, you list 3 reserve judgments.
Yes.
One of which you say was reserved on the 7th of September 2015, the one on the 5th of February this year, and the other one on the 24th of November 2015.
Yes.
Any of those judgments been delivered?
I think the one for the 24th of November was delivered. In respect of the older judgment of the 7th of September, it's an appeal. I did a draft judgment. I was sitting with a judge that has since retired. I gave him the draft, or I emailed him the draft, having struggled to get his contact details in December last year. I followed up with him on numerous occasions and was struggling to locate him. And when I did, he indicated that he could not recall the matter and he required for a transcript to be provided. I'm aware that he has since been provided with a transcript, and they actually phoned me last week and said to me that he wanted to discuss the judgment with me, but I was in court, so he was unable to reach me for us to have that discussion. The one for I think the 5th of February is still pending. It was a highly complex matter, and I'm working and finalizing the judgment. It should be handed down next week.
That's fine, the 5th of February one. Thank you, Chief Justice.
Thank you, CP. Commissioner C.
Thank you, thank you, CG. Good afternoon, Ms. Masipa.
Afternoon.
I had 3 questions, now it's 2. Because Commissioner Fourie took 1. But firstly, I'd just like to know your practice, Mogere Bosisiwe S. Masipa. How is it doing? I see you're based in Field Street in Durban.
Yes.
And what are you more involved in, litigation, conveyancing, or what type of practice, and how successful is it, and your client base?
It's a litigation practice. As I think I indicated earlier on, it used to be a thriving practice because I had work from parastatals, from private sectors, but then when legal advisors of institutions leave and new ones come in, they change and brief different people. It's doing okay under the circumstances.
But work has been taken away because of the change of legal advisors and things like that.
Yes, that's correct.
But the other question relates to your financial and proprietary, the Section 3. Now you list quite a few CCs there, and many of them you've indicated in the final process of deregistration.
Yes, that's correct.
Now, I'd just like to know, why now? Is it preempting an appointment to the judiciary? And why do you want to deregister from these companies? And in particular, there is a company called Tobogadi Trading and Project CC,
Yes.
which is in business.
Yes.
Can you just tell us what business activity is involved here and what type of business?
It's actually not trading, so there's no business activities. I wrote in business because it's still registered, but there's actually no activities in that CC.
Just to follow up, Chief Justice, I see, but in question 2, what steps do you propose to take in regard to your directorships and private business interests if you are appointed to the bench? You say, sell or close my practice, which is Masipa Incorporated,
Yes.
and sign over my members' interest to Topogadi Trading and Projects.
Yes.
Now you say it's not trading, but you want to sign over your interest to
Yes.
Topogadi.
Yes, it's because there's numerous business ventures that it's a company that I own with my mother, and there's numerous business ventures that we were contemplating going into. So hence I'm saying I will then sell over my members' interest because I'm not the sole member of the CC, they would still want to proceed or continue operating.
And just finally, CJ, the type of activity of this business, are you getting work from the state? Are you getting parastatal work? Is it contracting or whatever? I know it's not a legal business. I mean, nothing to do with your legal practice, but what type of business is it?
It has not had any type of work ever allocated to it. It's in fact mainly my mother's business, but I bought into the idea of what she wanted to develop, and she was working on some commercial petroleum things with private companies and not with parastatals or with government. But all that she has done is to apply for a trading license, and that's it.
Thank you.
Thank you, Commissioner Singh. Commissioner Ntlama.
Thank you, CJ. Good afternoon, Ms. Masipa.
Afternoon.
Yes. On page 6 of the form, you made reference to the Constitutional Court cases where you have assisted the councils
Yes.
to draft papers.
Yes.
Just 2 of those, and how have they fared at the Constitutional Court?
Well, in both instances, there was a need for a condonation application. And in the first one, a condonation was granted, but the court felt that, or was of the view that the decision of the Labour Appeal Court, it was a labour matter, was correct, and therefore dismissed. They granted the condonation, and then they dismissed the leave to appeal because it was a leave to appeal. In respect of the second matter, we're still awaiting the outcome.
Coming from KwaZulu-Natal, there is a critique against the Constitution that it is a Western concept document. It has come to be imposed on us. So, in the light of the critique against the Constitution, how would you use, if you do get this opportunity, traditional values to interpret the law in a manner that will use those traditional values as the primary source of law without offending the so-called beacon of hope?
Decision makers are called upon by Section 39 of the Constitution to always take into account the values of the Constitution in taking the decisions. The issues of cultures, the issues of tradition is catered for in the Bill of Rights, and when faced with having to make the decisions, it's always a requirement that one takes into account the traditional or cultural aspects.
Thank you. Thank you, Prof. Commissioner Nyambi.
Thank you. Afternoon, Ms. Masip.
Afternoon, Commissioner.
Do you believe that judges have a role to play to assist the public to understand the significant role of the courts?
Yes, I do. That would ordinarily happen in the manner in which judgments are written. If judgments are written in a way that members of the public can read them and understand them, then that would go towards achieving that role.
As a woman coming from a rural province, with your experience in terms of being sometimes undermined, percentage-wise, do you find a meaningful percentage coming from those that are educated or rural poor without education?
Pardon, can I please ask you to repeat the question?
You said you look young,
Yes.
of which is true, and you are a woman, and many a times you indicated that men undermined you.
Yes.
And there's an instance where they get to a room and they thought you are something else,
Yes.
yet you are the one who is going to assist with that case.
Yes.
So I wanted to check in terms of percentage-wise, are you being undermined by only people who are highly educated, or it's only rural poor without education?
It mainly comes from the educated people. That's what the experience that I've had. The poor people coming into the judicial system have no experience in issues that come up, and they seek advice. They seek assistance from practitioners. They seek assistance from presiding officers, from judges, and most of the time I've not had problems. They listen to advice, and they take advice, and they believe that they are given proper advice.
The last point from my side is the issue that has been raised many times here,
Yes.
the one from the Law Society.
Yes.
With you learn until you die. So with your experience from questions that have been asked and how issues have been raised, do you think your understanding before the questions and the engagement, you still hold the view before coming to these interviews now?
Yes, I do. I have reflected on the issue on several occasions. I've obtained opinions from senior counsel, and all of them are of the same view, that having taken a bona fide decision in what I believe to be the best interest of my client, then the Law Society ought not to have arrived at the decision that they arrived at.
Thank you, CJ.
Thank you, Commissioner Nyambe. Commissioner Nokesi.
Thank you, Chief Justice. This, in fact, this appeal, because you wrote, you record it as an appeal you record it as an appeal, will be heard by the High Court of KZN.
Yes.
And if you are appointed, you will be a judge in that division.
Yes.
Is it not going to make some discomfort to your colleagues who must listen to this matter?
Yeah.
When they listen to your matter there, is it not going to give some discomfort, at least to your colleagues and to yourself?
I do not believe so, and I say this because during my acting stint in the court, I have observed cases that came in that related to the judges that are currently appointed and sitting there, and all that was done was that judges from other provinces were appointed to come in and deal with those matters.
Commissioner Malema.
Thank you very much, Chief Justice. Now, this issue of the professional body, does the appeal suspend the earlier decision by the body? So when I look at you now and look at any other lawyer who is not found guilty by the professional body, you enjoy the same status pending the outcome of the appeal.
Yes, that's my understanding.
So it will be incorrect for anyone to want to pursue you on the basis of the earlier judgment because you have made an appeal.
Yes. In fact, my initial approach is that the matter is sub judice, but then in order to be, I would say, transparent to the members of the committee so that they get to understand what is happening, I felt that I would answer the questions.
Sub judice doesn't refer to those things before court.
Pardon me?
Sub judice doesn't refer to matters before court.
Yes, it does.
So this is not court. It's a professional body. So the matter is not sub judice.
The matter is pending in court.
The appeal is done
The
in
appeal
court.
is- yes, it's
okay.
pending in the High
okay.
Court.
Now, ordinarily, those of us who come from previously disadvantaged background, post 1994, when we graduate or finish school, look for jobs, part of what we do is also to register companies because we try almost everything for survival.
Yes, that's correct.
And your registration of companies was when you were still trying to find yourself, like all of us in the process of growing up, trying law, trying business, trying all sorts of things.
That is correct.
Now, the last question is, having the advantage of looking young and being a woman, if we appoint you, does it project this body on a good light? A young-looking woman judge, does it enhance the image of this body?
I believe it does because young members, young people in the community would also buy into, the confidence of the judicial, a fair judicial system that would be there.
Thank you.
Thank you.
Thank you, Commissioner Malema. Commissioner Schmidt.
Thank you, Chief Justice. I'll be short. I understand that you were shown the comments by the advocates for transformation.
Yes,
on your candidacy. Can I just have your view, because I think it would be fair on you just to comment. And it says in conclusion that this candidate's impediment is a relative lack of the necessary experience to hold a position on the KZN bench at this time.
Yes.
She ought to be given further opportunities to hone her skills on the civil bench.
Yes.
Preferably before we can say with any conviction that we support the nomination.
Yes.
Would you like to comment?
Yes, I'm aware of the comment. I looked at the comment and I felt it is unclear to me in what respect they're saying I lack the experience to hold the position in respect of civil matters. And I say that because, as I indicated earlier, as a practitioner, I've been dealing with civil matters, and I've also, acting in the High Court, done 4 civil sessions. And in view of that, I believe that I have gained necessary experience in dealing with the matters. I think I should add that, as I indicated earlier on, that I sit as an arbitrator, and the same procedural requirements that apply to civil matters apply as well. I've also sat as an acting judge in the Labour Court, although there are different rules in the Labour Court. The rules of the Labour Court also refer to the rules of the High Court relating to civil matters, which I'm quite familiar with and have been working with those for years.
Well, to the extent that somebody might have a problem with age, I was 36 when I was appointed to the High Court. Your former Judge Zondo was 37, Hlophe was 35, Madlanga was 35, Kate O'Regan was 35, so don't worry about that. Commissioner Mutim.
Thank you, Chief Justice. Ms. Masipa, I'm now going to test your sense of judgment. You'd know that in terms of the Superior Court, if you intend suing a judge, you'd need consent from the judge president. Is that not so?
Yes, that's right.
What would be the rationale or policy consideration of the enactment of that section?
The rationale for the requirement?
Yes.
I believe that for the judge president would be as the person who's obviously in charge of the division would be in a position to determine whether there is a way of resolving the matter in order to protect the integrity of the judicial system, and also to determine whether the matter can be had or dealt with in that jurisdiction, or whether there would be a need to have the matter transferred to another jurisdiction where there would be impartiality in dealing with those matters.
Now, it is to protect the independence of the judge and the integrity of the system that judges make decisions without fear or favor.
Yes.
Now, how would that mechanism, safety mechanism, be applied if you get appointed, you are the judge, but litigation is proceeding and the head of court doesn't have instruments to do what you and I just agreed need to be done before you sue a judge?
It's unclear to me as to what you mean when you say he does not have the instruments.
The section only empowers him to give consent prior to the institution of the matter.
Yes.
For the judge.
Yes.
In your case, if you are appointed at the time of the institution of the matter, you are not a judge.
Yes.
When you become a judge, the matter is continuing.
Yes.
So that section won't assist, isn't it?
Yes, it will not.
So how do we protect the integrity of the system or the judge?
The integrity is protected by arranging for judges that are from outside the jurisdiction to come in and deal with the cases. It has happened that some of the judges that are sitting, as I indicated earlier on, have personal matters that would not necessitate the Chief Justice being advised, since they were not being sued.
Yes, you're repeating, I heard that.
Yes.
Can I ask my next question?
Yes.
Without debating the issue with you. Had this appeal been heard and the appeal was unsuccessful,
yes,
would you still apply for the post?
Yes, I would have. As I indicated earlier on, the Law Society rendered their decision, and their decision was that I pay a fine. And that is all that, if my appeal is successful, all that would be required of me is to pay the relevant fine to the Law Society.
So it's just a commercial arrangement according to you?
Yes.
Thank you.
Well, if it is any comfort, constitutional court judges have had to come before you about their own matters, before us about their own matters, and there's another one looming. Same judges of the same court before the same court.
Yes.
And there's no one else who can step in. You're excused.
Okay. Thank you.
The beach with Cape Town women. Hmm? You think so? Happy face. Thanks.
Now you can add to it. While I was working, I was thinking of you.
Well,
Way up in the sky again.
elections August 3rd. Well, thanks very much, Alicia. Yes, indeed, it's a very open and transparent process. The media can actually, in fact, is here observing since on Monday when the hearings started. So, yes, indeed, the members of the JSC, it's a very open process. They get to quiz these candidates. The candidates themselves get to put forward their visions for whatever court they are applying. So it's a very open and transparent process indeed. And I guess to that extent, it's one of the things, one of the safeguards, if you like, of our democracy. No one can say we didn't know who this person is or we didn't get a chance to find out who this person is. The nomination process also, I mean, people nominate, they send the forms through, they are scrutinized, they are sent back and forth, whatever questions, clarities that are needed to get supplied. And the same happens when the hearings themselves are underway. Well, on Monday evening, it was there were 7 candidates for the positions or for posts in the Supreme Court of Appeal. And today it was 3 candidates for the positions of the Deputy Judge President of KwaZulu-Natal. And as we speak now, it's several candidates are up for several positions that are available in the High Court in KwaZulu-Natal. So far, those are the positions for which interviews have been held. But perhaps a point one needs to make is that there's a great deal more value in this process, in other words, beyond the positions themselves, because it's where members of the JSC, from the person presiding the JSC, Chief Justice Mogoeng, right down to the members of Parliament who dabble in and out of these issues, they do get a sense of the challenges facing our court system, the challenges facing the judiciary specifically, and get to have a better appreciation and hopefully get to think around some of the things that need to be done to correct whatever wrongs there may be in the system. Issues of access to judiciary, to justice, especially for the poor, have come up. Issues of transformation have come up. Issues of just generally the state of affairs in the courts, where there are people who apparently don't pitch for work at times. The resources, unavailability of resources or inadequate resources, at times less than competent people being put in positions where they are supposed to really oil the wheels. In fact, as one person put it, if you've ever wondered why at times the mills of our court systems don't seem to grind as well as they should, these sort of hearings give us a sense as to where the problems are, where the challenges are, and give both the legislators and the Chief Justice and the Judge Presidents an opportunity to actually start looking at those challenges and do something about addressing them. Alicia? Well, for a couple more days, let's remember there's still other provinces, including Limpopo. And in fact, almost all the provinces, the interviews still have to be conducted. Okay, what was the thing about?
Just to punt that the event is being streamed live, so they can get that on the website.
About being white or black, it's such that it must be the first thing that must come up when we talk about transformation. But you'll make your own comment there about why you react that way. The first thing, though, that I want to is when you look at transformation and assessing it in terms of speed and quality.
Yes.
What's your assessment, just on speed and quality? You can make a comment on the first one if you want to.
Again, if I can also, there was also a comment made on one of the advocates for our transformation that there was nothing in my CV dealing with transformation. If I could deal with that as well, but my views is yes, transformation is important. But at the end of the day, the litigant and people coming to court are paramount as far as all of us are concerned. And one needs to have a perception that when one leaves court, one's had a fair hearing, no matter who it is. And that's why I think judges bring life experiences of anything to the bench. And those life experiences have to be wide and varied. And one also has to be, it's a delicate balance. One must not draw competent persons away from the bar and the sidebar and leave a dearth of persons that want someone of experience to represent them, to take those persons away and put them on the bench. It's a very delicate balance. But over time, and unfortunately we live with our past, and it has to slowly change, but it has to be done at the level of the litigant, and the persons coming to court should always be confident that they're getting a fair hearing from both sides. In other words, the person representing them and the person hearing it. I can't take it any further than that. Just at the level of, on my CV, if one, as I understand the question or the comment as well, there's nothing on my CV about transformation. I don't view it as something that to make points on your CV or to gain points on your CV, but I cannot say that I've never been in a position where I can actually dictate large policy about transformation or change. But where I have been involved and been in a position to actually advance people, I've always done so. You'll note from my CV, I was the chairman or chairperson of one of the larger football and running and sports clubs in Durban. Now, that was at the end of the 80s, early 90s. When I became chairman, and I used the term, it was run by some very narrow-minded people at that stage. And I worked hard and helped transformation of bringing all races and all genders into the club. The criteria being if you're a good runner or a good sportsman, this is where we are. I also developed teams. I managed teams, and I did a lot there. You'll also note, and hopefully I improved those lives. I don't know. When I was you'll see I was on the governing body of one of the larger boys' schools in Durban. At that stage, I was the chairman or dealt with disciplinary issues, so code of conduct fell under my portfolio. There was a challenge to one of the other schools in Durban dealing with a nose ring, and there was litigation over it. That issue arose at the school I was on, dealing with young learners of the Muslim faith. If they wanted to lead prayers, needed what was styled then as a virgin beard. And there was the first reaction from everybody there, we have a code, this is our uniform, this is what it is. I brought in a policy there that all that the persons had to do was ask for an exemption to that code, and on proper and objective grounds, and after the application was made, many of the young learners who were then going to lead the pairs were allowed to grow beards, and it was accepted and went all the way through. At the bar itself, I don't think there's 4 years or 5 years have gone by that I haven't had a pupil. I even had a pupil when I was a silk. So I've helped in training. I've been actively involved in training. I've also formed associations, as one can call it, with juniors, either them calling for me as juniors and so forth. And always where I can, have introduced persons that would not otherwise have been known to the larger firms or the firms that I was associated, recommended them. And a couple of them, or two of them that I can mention now, have got decent commercial practices from there. So although I can never say, yes, I have done, or that there's no written document, I would hope that I have helped transform those persons' lives. But I view it as something that should be done, not to score points on a CV, if you don't mind me saying so.
Thank you very much. What are the two most critical challenges of the bench in KZN currently?
So, I don't know. I have a very, very positive view of the bench in KZN. The judges there are very competent. They're very approachable. It's a hard question for me to answer. I don't know. I don't have to answer. But I have no complaints about the KZN bench from a practitioner's side of things, and that's the only area that I've actually viewed at the moment.
Well, I'm aware that we have a shortage of judges. If you look at other provinces,
yes.
Now, that's the first challenge that
Yes.
you are saying you're not aware of.
Well,
but I was going to ask you a question anyway.
Okay.
What do you think is the historical cause of this shortage? Is it because that province has a dominance of Zulus who may be assumed to be wanting to sort out their differences through stick fighting or something, and therefore not requiring courts and judges?
I don't think so. I've never seen that, as again, from a practitioner. At the level of, yes, there's a shortage of judges. Just, again, from a practitioner, when the trial rolls, although the allocation system is a new one and it seems to be falling in place, but just as a practical level, when one goes up to Maritzburg, although there's lesser trials on the roll, the workload of the appeal court there seems to drain away from the trials. So yes, I think there's very much so. Yes, a shortage.
That's a challenge.
And I understand what you're saying. So possibly I misunderstood your thing. Yes, I think as a practitioner, there ought to be more judges allocated to that division because of the workload. I think there's a massive workload on that, both in Durban and in Pietermaritzburg. As far as fear of coming to court is concerned, no, I don't. I think the litigants are quite happy in that court, the ones that I've come across. I deal a lot, or have done a lot, with personal accident type cases, personal injury type cases, actually mainly for plaintiffs. And the feedback, and then my clients and colleagues' clients, I've heard no adverse comment from anybody.
This much spoken about reluctance on the part of women generally, and black women in particular, to join the bench. Have you observed anything? Are you, if pointed, what role, if you find that there is indeed shortage, what role do you think you will play as a person, as a DJP, if you
That's a long way.
No, sorry, as a judge.
As a judge. I thought I'd come in the wrong time. I do apologize.
I have a hang up. Yeah. What nevertheless?
It needs to be encouraged, but just go back to my previous comment. There are some very exceptionally competent senior female advocates at the bar. And they are needed there for a time, possibly, until further people come through because of our past. Then, yes, a transformation through. But I have that fear that if all the very competent advocates go to the bench, it leaves a dearth of competence at the bar or not on the bench. Well, it's a balance. It's a balance. But very much so, yes, in time, there should be more females, should be on the bench. I think we've lost one judge recently that's moved off to another division, but yes, very much I support that.
You said you speak isiZulu as well.
Ngcono ngiyakhuluma ngiyazama angikhulumi kakhulu ndaba khona into engicaba ngazi ngigcwalisa ngesingisi njalo. Nento futhi ngiyafunda isiZulu isikhathi ngengane yabona ngihluleka ukufunda ngiyahluleka ukubhala futhi ngiyakhuluma kuphela.
Ngiyabona. Icala ungalithetha ngesizulu.
Excuse me sikancecelela?
Icala ungalithetha ngesizulu.
Into ngiyakusaba futhi ngikhona phakathi enkantolo ngiyacabanga isingisi manje ngiyakutoleka njalo yabona. Manje futhi siyaxoxa kahle. Then ngiyakusabisa futhi ngiyakhuluma isiAfrikaans futhi njalo ngiyakuthokeleka ngeEnglish. Na ngiyakutranslate njalo wena ngiyakusaba. Mafuthi siyaxoxa.
Cha uyazama. Thank you very much, Chief Justice.
Thank you, Premier. Uyashaya impela ba.
Njalo ngiyakusaba ukukhuluma phela into ukuthi unqwaba ngazi.
You know, there's a mistake here. The reason why I thought you had LLM and MBA is that there is a nomination of an advocate Gordon attached to the reverse side of your own nomination.
Well,
and this person is being nominated for the Western Cape. I don't know how this happened, but mistakes do happen.
Well, if I could accept those credentials graciously, I would do so.
Commissioner Mutimele.
Thank you, CJ. Can we continue in Zulu, this part of? I didn't hear you. No, thank you, Counsel. There is a judgment of yours.
Yes.
The Singh judgment against the Minister of Transport and the MEC in KZN. The one that relates to the rules of the residents.
Yes.
Remember that judgment?
Yes, I do. Very much so.
Beautiful judgment. I enjoyed reading it.
Thank you.
But the issue, there were 3 applications in one, as you style them: the rules application, the spoliation, and the trespass.
Yes, and then the rules application encompassed the counter application as well.
Yeah, but the facts were the same. I mean,
yes,
it was the interpretation of those rules and the interplay of the freedom to contract and the public interest. Very narrow issues. I see you delivered the judgment on the judgment was heard. The hearing was on the 12th of June 2015.
Yes, it was.
And the judgment was handed down on the 4th of February 2016.
Yes.
Approximately 8 months.
Yes.
Any explanation why?
Yes, I can. If you'll note the judgment, it's quite a lengthy judgment. I was hoping, I finished my stint at the end of June, and I was hoping to use the July recess to work on that judgment. Unfortunately, I walked into a practice just with urgent applications and matters that I had to deal with. I spoke to both counsel concerned and said, I need time. It wasn't the type of judgment, and I hope it comes through from the judgment itself, that one can write piecemeal. One just needs to sit down and concentrate on it. And I said to them, I can only really do that during the December recess. And both the counsel were quite happy. They'd spoken to clients and said, rather deal with it properly and produce the judgment. And you can see it's over 100 pages. That's the reason why I took time, because I didn't want to rush it, and I wasn't able to get to it with sufficient chronological period of time because of the pressures of my practice. And if I can just add on from there, what has happened, which is not evident from what's placed before the Commission, is that there's been an application for leave to appeal sought on the application and convention in the rules application. Otherwise, the rest of the judgment, there's been no challenge to at all.
The bulkiness of the application is in part duly because of the quotation, the verbatim of the rules of the association.
Yes.
That's what makes the bulky.
Yes, and I had to put that in to make it read sense with respect, yes.
Thank you, Sija.
Thanks.
Thank you, Advocate Mutimela. Commissioner Helens?
Mr. Topping, you make reference to a reserve judgment that you have.
Yes.
In the matter of Absa Bank and Garrison Hardware.
Yes.
And it's now February. You say it's reserved because you only received written argument from counsel during January 2016.
Yes.
Does this emanate from your acting appointment in June, July last year?
Yes, that judgment has been handed down. I've completed it and it has been handed down. And again, what happened there is that became a bit of a perpetual trial. It went on and on and on. And what happened is that the council agreed to give me written heads and not give me oral argument. I received one during December, one during January, and I had to go back or try and ascertain from the plaintiff's counsel whether they wanted to reply to the other heads, which I only ascertained towards the end of January. And then I sat down and wrote the judgment, and I finished it during February, and it's been handed down now.
So the hearing, was this a trial or a motion?
No, it was trial. It was a part heard, and it went on for a number of occasions. I think it went on during September.
Okay.
And then it went on and on. And again, although the claim was only for 180-something rand over a telephone system, there were 5 special pleas raised on the National Credit Act, and it just turned into a perpetual trial because the defendants challenged every single document, so I had to deal with all that. So it turned out a bit of a lengthy judgment.
You've answered my question. I
Thank you
thought
so much.
it was a situation where you heard it in June or July and then only got heads.
No, it wasn't. No.
Professor Ntlama.
Thank you, CJ. Good afternoon, Advocate.
Good afternoon.
Yes. There is a complaint from a certain Mr. McHenry.
Yes.
Which you signed off on the 10th of June last
Yes.
year. Has it been sorted out by now?
I've heard nothing further since the memorandum, and I've heard no further, but I thought it pertinent to put it up because it was a complaint raised. And I assume it's been sorted out. There's been no comeback to me, and I don't know if the Judge President might assist. I really don't know.
So let's assume it comes back and we give you this opportunity.
Yes.
What impact would it have on us as the judiciary?
If one looks at what actually happened, and I'm working from memory now, please bear with me. It was a situation where it was a gentleman that was acting for himself in motion court. There were 2 files placed before me on the unopposed roll. It appeared from the documents, and I think I made the comment in the memorandum that I wrote, that the papers were not in order. There was just papers stuck in both files. I had to go through them to try and work out what was going on. But it appeared that the 2 had been consolidated at some stage. One was relating to a judgment that had been obtained by default for the sale of a movable property, which there was a rescission application pending, and the 2 were consolidated. And there was a note on the file that it appeared that both applications had been withdrawn. So when it appeared before me, I tried to get clarity on that point and tried to ask the counsel. There was the defendant, I think it was at the time, or respondent, was represented by counsel, although the applicant was in person. I tried to get clarity to get them to go and listen to the tape to tell me what actually happened because it was disputed. The applicant actually said, no, it hadn't been withdrawn. So I was sitting with that situation, and I explained to the gentleman in person it wasn't on the opposed roll. It couldn't be heard until such time as the record had been listened to and a transcript obtained, which the respondent's counsel offered to make sure that that happened in time. And it was for that reason that I then adjourned it to a period for that to transpire. And again, I don't know what's transpired with the actual application itself. So with respect, I think I dealt with the matter properly. I do recollect that the applicant himself endeavoured to come and see me in chambers afterwards, and I said it wasn't appropriate. Well, I let my registrar advise him that it wasn't appropriate to do so without the respondent's counsel there. And I think he approached the then civil judge on duty with the same request and was told the same thing, and then I heard nothing further. And then I received a note saying there had been a complaint, and I drafted that memorandum. So with respect, I think it was dealt with appropriately, and I cannot see any comeback if the matter is taken any further.
Thank you. President Badi.
Good afternoon.
Good afternoon.
Mr. Advocate Topping. I'm just worried about age. I mean, some people can retire at 65 after 20 years service.
Yes.
Your age is now 61 and a half years.
61 years.
Why do you have to wait so long before you made yourself available for the bench?
I think it goes back to that notion that I have that I want to be sure I can do something before I do it. I always said that I would take Silk 20 years into my career. I applied for it in 2012, which was 20 years, was held up for 2 years, and I ought to be a Silk for 4 years now. But just at a level, I think age is a concern for everybody, but I've been someone that's always been younger than my age. I played over 35 league soccer until I was 50. I'm one of those type of people. I just couldn't chase the younger people anymore to get the ball back. But no, I don't see it as a problem. And I think the moment I stop working is the day I'm going to keel over, because I've done it my whole life. I'm an active person. My children are in the 20s. My wife is younger than me. No, I don't see it as a problem at all. I'm a young person, and I intend to 15 years of service if I can, yes.
Regrettably, at 75, you'll have to leave anyway, even if you want to stay
14
on.
years of service, yes.
Thank you.
Okay. But I really don't see it as a problem. I'm an active person, yes.
You are excused, sir.
Thank you very much. Thank you very much for your time.
It's going to be time for deliberations. If the room could be cleared, please. Yes.